should you pick for your power of attorney when you have a blended family? Hi, my name is Alec Osland, and I'm an attorney at the Yanowitz Law Firm, where we've been assisting families in Minnesota with wills, trusts, and probate for over 30 years. If you have a blended family and you're maybe in your second or third marriage and you have adult children, there's sometimes the question of who should you pick as your agent and your power of attorney. Generally, anytime someone gets an estate plan, they get a power of attorney. And the power of attorney is a document that allows someone to act as you regarding really any decisions that are non-medical. What that does is that gives that person the ability later on to act as you if you become incapacitated and are unable to handle your financial decisions. Even if you aren't incapacitated, that person can step in and act on your behalf without any court involvement as well. And that is one of the big benefits of having a power of attorney is you get to decide on who you want to be able to step in and really sign a document or act as you, even while you are capacitated. And we're not relying on a court and a judge to determine whether you are capacitated or not and who is going to step into that role to start making decisions on your behalf. And so one of the large questions that I get when I have clients who have a blended family is who makes the most sense to be that agent? Do we want it to be the spouse, or does it make more sense to have that agent be the biological children of mom or dad? And my answer to that question is always, it really just depends on the dynamic of the relationship. We need to look at what are the ages of the children, how long have mom and dad been married for, what is the goals and the plan of the estate plan itself. Are we leaving everything to that surviving spouse or disinheriting them? Was there a prenuptial agreement? So there's a lot of variables that come into play when thinking about who should we name as the agent in regards to should it be that spouse or should it be our adult child? And there's really not a great answer to that because every situation is different. What I do find is generally for my clients who have their own assets when they come into the marriage and they're keeping everything separate, on those situations, we generally appoint the biological children as the agent, whereas in the situations when we're going to start merging assets and everything is going to be blended and it's going to be left to the surviving spouse upon the death of the first spouse, in those situations, I see a lot more of my clients naming their spouse as an agent before their children. So it really just comes down to your goals and wishes regarding your estate plan. One thing I do want to point out, though, is a mistake that I commonly see, and one that I talk about my clients with, is just naming someone on their power of attorney because they feel they have to include them. And so what I mean by that is a situation where we have maybe multiple children and there's one child who is kind of left out. We're not naming them as a successor trustee or a personal representative or naming them on the healthcare directive. The parent feels bad, so they say, well, I guess I will name them as my power of attorney agent. And whenever I hear that, the clause of, well, I guess, it throws up some red flags. And the reason is that power of attorney, it is a very, very powerful document. And it's something that needs to be taken seriously because you are allowing someone to act as you. They are signing on your behalf. Yes, they must act in your best interest, but at the same time, you are giving them access to everything. So you want to think very clearly, can you trust this person? Are they always going to act in your best interest? Because again, it is a very powerful document. So with that being said, I hope you learned a lot from this video, and make sure you subscribe to our channel to find out when we post another video. Thanks. Have a great day. Bye.